petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment because those are matters beyond the purview of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light.
Sunrise
to begin with,
3 FM, the best in the morning.
We respect the right of Her Ladyship, the Chief Justice, to express any view that she holds about the matter in question, to the extent that it is consistent with the rules, because the Constitution makes it clear what the processes are in determining a matter of the sort that we are engaged with. The Constitution requires confidentiality on the part of all parties. It is the reason why the presidency, on behalf of His Excellency the President, has refrained from commentary on the matter beyond stating what the President has done in compliance with the Constitution. So it would have been desirable that that constitutional provision was respected.
Sunrise on 3 FM, the best in the morning.
You're live here on Sunrise on 3 FM 92.7. It's some 46 minutes after 8. And let's go on to the phone lines now. We have two legal luminaries joining us. Chris Leberach, Malm Hess is a private legal practitioner. Osman Alassan is also a private legal practitioner. Gentlemen, good morning. Thank you very much indeed for your time.
Good morning, and thanks for having me.
Great. Chris, let me begin with you and ask you, did the Chief Justice on suspension go beyond what the provision of Article 146(8) says, that all of these sittings should be held in camera? Did she overstep her boundaries as provided by law?
Come on, the predicate of your sentence, I didn't hear the line.
I'm asking that yesterday the Chief Justice on suspension held a press conference detailing some of the happenings at the committee that's supposed to be sitting in camera per Article 146(8). I'm asking, okay, did she overstep her boundaries as, provided by law?
Okay, all right. If you look at the Adechum case with Attorney General, Justice Dr. Ba, in his dissenting opinion, corroborated Article 146(8), which meant that all matters relating to this particular proceedings must be held in camera. And it being held in camera means that whatever happens in there must not be divulged to public scrutiny. And we realize that that is what happened with Right Equity, where the petitions were flying all over,
right,
and the matter failed. So yes, I would conclude and say that it was unwarranted for her leadership to have come out to divulge all of that, to the extent of going into the petition and, delineate all that allegations leveled against her by the petitioners, including the intricacies happening at the committee hearing, and some allegations also against some committee members, conflict of interest, refusal of persons on the committee from hearing the matter and all of that. These ought not to come out. But be it as it may, she's also of the belief, and that crosses out of the legal remit now. She has now crossed out of the legal remit or threshold, which requires that such things ought not happen. Now, she has engaged herself in the public hailing, where she's also seeking to trade a tooth for a tooth because she believes that she has been bastardized. A portion of the public has grown apathetic against her, and she wanted the public also to know what the issues are. So more so, she's also fighting her case in public. But that is not the rules as contained in the Constitution, particularly Article 146(8). And also, if you look at Ghana Bar Association versus Attorney General, it is also there clearly. So the authorities at the Supreme Court speaks the fact that the Chief Justice ought not to have come out to divulge matters of the proceedings to the public. But like I said, she is also trying to balance public opinion as measured against her. But that is out of the legal remedy.
Now, Osman, let me come to you, counsel, and ask you, did the Chief Justice miss her way to the court? Because the commentary in the public domain seemed to suggest that the head of the judiciary suddenly chooses not to go to the court, even though there's record to prove in 2023 that she said that judges that made public pronouncements about cases before the courts should be held in contempt with stricter sanctions. Suddenly, she is making such public pronouncements. Did she miss her way to the court?
I don't think she missed her way to the court. She went to the court and had a verdict. She went to the court over which she herself was presiding and had a verdict. And going to that court, that's what sometimes I keep saying. Sometimes silence is the most powerful weapon. I think that all these things, as my colleague said, were unnecessary. Apart from the violation of Article 146 in some instances, it is also needless. What is the Chief Justice seeking to obtain or to achieve by holding a public conference on the proceedings that the Constitution intends to be covert, to be confidential? Why? What does he want to achieve? Does he want us Ghanaians to think that she is a victim of some political persecution? Is that what it is? But even if that's the case, that's not what we Ghanaians will judge her by. We are not going to judge her by whatever happens in these proceedings. Ghanaians will judge her by what she did while she was in there. And they saw it. And for me, she should have just quietly submit herself to the process. All other remedies that can be sought even against the final recommendation and the final action. If it's adverse to her, there are avenues for remedies for all that. What the Constitution doesn't contemplate is for her to now come out even before the close of the proceedings and be talking about what happens in the proceedings. And for me, some of the allegations are actually, in all humility and with due respect, very, very flimsy. To make a complaint about the venue, and the complaint is that that venue is a high-level security zone, and that other proceedings of that nature never happened there. As for me, seriously, a flimsy excuse. Not only flimsy, but it's even counter beneficial to the process. Because a procedure that the Constitution intends to be confidential definitely will need to take place in a high-level security place. And a procedure that has to have the Chief Justice herself in attendance has to be, and members of the Superior Court, they are sitting in there. It has to be a high-level security place. So, for me, coming out as a matter of public conference and to tell people what is going on, as my colleague, I agree with him that some of that can constitute publication of the procedure, which in itself is a breach of the Constitution. It's a breach of the Constitution.
Right.
No matter how a constitutional provision is deemed to be improper, to be wrong, until it is amended, it remains as such. So any advocacy should be against the amendment, not a flagrant violation of what stands now.
I see.
But unfortunately, yes, unfortunately, that is what the Chief Justice is doing. Unfortunately. And I say that the more she does that, the more she exposes herself to the prescriptions that the Constitution gives for removal. The more she does, the more she tries to defend herself publicly, the more she opens herself up to the... Because why are they taking her through this procedure? And let me say that no matter how much, I think I said this on this platform before, no matter the motive of any person, John, to remove you from where you are, if there are rules prescribing what must be met for you to be removed, and those prescriptions are not met, no matter how vile the motive is, they can't remove you from there, can they?
No.
No. The rules say if you steal, they should dismiss you. You haven't stolen. And somebody hates you and desires that you be outside there and say you have stolen. The stealing is not proven. Will you be out? Would you be dismissed?
I see. Let me bring in Chris. Chris, I ask you now, until this unsolicited information from the Chief Justice regarding where the sittings were being held, we didn't know that it was the Edu Lodge. Well, now the public knows, including those who support the Chief Justice and those who do not support the Chief Justice. Should that location be changed, given the fact that Article 1468 says these proceedings shall be held in camera?
All right. So the choice of venue, is not seated in law. The choice of venue is not seated in law. The choice of venue, the could have been guided by our historical antecedents. That's our legal history. And that is where there could be a certain leaning of sympathy towards them. Aside that, there's nothing untoward. Why am I saying this? It is because it is associated with the demise of the judges and also the military officer who was slain.
Major Samakwa, right.
And guided by that, it had always remained a scar on the mind of the judiciary. So in any legal system, and when we come into jurisprudence and especially interpretation, we look at the legal antecedents, and based on that, one could infer and say that could the venue be changed? If yes, based upon this factual evidence, then that is fine. But it is a reminder of the horror of our past. It has nothing to do with the petitions brought against her leadership. At the end of the day, the petitions brought against her, however the conclusion may be, it has nothing to do with the venue.
I see, but then do you find it beyond the history? and the trauma that the learned Chief Justice seemed to suggest that she's going through, that the venue was chosen to, if you will, unsettle her. Those are my choice of words. Do you get a sense that exposing the location to the public when these meetings are supposed to be secretive in itself is problematic?
Oh, if it has to do with a claim of one of the members being, as in Aqua, being a relative, it has nothing to do with it, because some other persons could also say the High Court reminds me of a proceeding a relative went through, and as a result of that, that person was placed at Sawam, or that person having gone through the court, they never trusted the system, and at the prison, the person died. So it can waive my right of thing. So we should divorce that from her personal relation with any other person. But just the issue about the judicial scar, that is more national. It goes beyond an individual's idiosyncrasies. But a national scar that reminds us of our legal history is one of interest, and not necessarily about her personal relationship with any of them. That should be divorced. So, yes, she having disclosed the venue to the public, it's a high security area. I mean, much as I do, nothing much would happen. But like I have said early on, the submissions that she did, she could have held on to that, because majority of all that she said were all contained in her supplementary affidavit that was struck out at the Supreme Court.
Right.
Now, in the situation where there's an adverse finding against her, I can only hazard to say that her last option would be to file the prerogative writ of certiorari to quash the decision that would come out at the Supreme Court. You get it? So, like my colleague said, she could have relaxed, because some of these things she's raising, the right forum is the court. It is not the public. The public has no legal tool or appellate tools to deal with her matter, rather than court sympathy and moral justification for whatever is going on.
I see. Osman, so I'm looking at the Judicial Oath, and that the Chief Justice swore. The final portion says that, and that I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will, and that I will at all times uphold, preserve, protect, and defend the Constitution and laws of the Republic of Ghana, so help me God. This is the oath the Chief Justice swore, along with the oath of allegiance. Did the press conference yesterday and the things that the Chief Justice said, whether she's swallowing pity party on the streets of public sympathy, or whether she is trying to protect and defend the integrity of the judiciary, did you get the sense that she was upholding, preserving, protecting, and defending the Constitution of the Republic of Ghana?
No, not at all. In fact, I see the contrary. I see the contrary. Because, I mean, let's be basic and simplistic. The Constitution says this kind of procedure must be in camera.
Right.
In camera is too big a word. It's Latin. It must be secret. That's what it means. It shouldn't be public. Nothing about the procedure should be made public. That is what the Constitution wants, and that's what the Constitution expressly demands. I think Article 1468, Clause 8 or so.
That's right. 1468, that's correct.
Yes. It's express. It's not to be gleaned by implication, by necessary implication. This is express. Make it in camera. Make it secret. Make it confidential. Make it covert. Don't let anything about the procedure come out. All right. Now, the Chief Justice, under the oath that you have just spelled out, is supposed to be upholding, preserving, and defending the Constitution. Defending the Constitution.
Right.
There is no interpretation that is going to be given to these express words that can yield any other meaning apart from the fact that the framers want the process to be secret. Because you can't interpret to get a meaning that is not consistent with the linguistic scope of the words that are present in the Constitution. There's always a link between language, linguistic principles, and interpretation. And so if the Constitution says it must be secret and you make it public, how can that be construed as upholding or preserving or defending the Constitution? It's the contrary, in my opinion.
I know that you gentlemen have to go and attend to some very important business, but so this will be my final question to you, Chris. I come to you now. Where do we go from here? The courts are still open. The Chief Justice has had a press conference, and she herself in 2023 has said that judges who comment on such matters in public while the matter is still yet to be concluded must be held in contempt. Has she put herself up to be held in contempt?
I mean, clearly she herself has run contrary to the law. And, I believe the legal fraternity agrees on that point. She herself has run contrary to the position of the law. And it's quite unfortunate. I also gather that she has filed a review. She has filed for review at the Supreme Court.
Right.
That will also be determined on its way. And for review, the court looks at exceptional circumstances. If the court is of the opinion, or the panel is of the opinion that what is brought before them demonstrates nothing of exceptional circumstances, it should be apparent on the face of the processes. The court will throw it out. If they find favor with it, that will be fine. But I believe she is bent on going on most of these emotional tangents rather than law. So let's see what comes up in the near future.
Lawyer Osman, where do we go from here?
We just return to the proceedings because there's nothing that is being done that can change what's going on, because it is moving. You see, something I like something Karl Marx said. He says sometimes events move with iron necessity towards inevitable results.
See,
there's nothing you can do about them. You just have to submit to it and see the outcome. You see, so it doesn't. All these things will not stop the proceeding from going on, unless, of course, there is a court order saying the committee's proceedings should be stopped. And the Supreme Court has already stated that once it's a constitutional duty, the court cannot injunct it from carrying out the constitutional duty. So we just return to the proceedings. No matter where it goes, we return to the proceedings. The proceedings will continue to the end. And for me, if she had waited and gotten the outcome of perhaps, just perhaps, the committee might not recommend that you should be removed. We don't know the recommendation of the committee yet.
Right, we don't.
Yes. So won't she feel embarrassed if at the end of the day, the committee recommends that no, for A, B, C, D, we don't find any basis for recommending that she should be removed from office. So we recommend that she remains in office. Won't she be shy of that? So for me, it's just the proceedings. No political sentiment or sensationalism can take away the truth or otherwise, or the veracity or otherwise of the allegations made. Number one. Number two, no political motivation or sensationalism can change the outcome if the constitutional prescription for removal from office are met, or if they are not met. That is all. I think what the proceeding is doing is to verify whether there is stated misbehavior or there is incompetence in the Chief Justice. That's all. And I think they should focus on that. Going to the Supreme Court and doing all this, I mean, in all humility, I don't think my colleague we all know, as a legal fraternity, it's so basic that you don't enforce your fundamental human rights in the Supreme Court personally. You don't do that. We all know that. That if you allege a breach of your fundamental human rights, the Constitution has given that authority exclusively to the High Court. Go there. But to see the Chief Justice herself taking matters of fundamental human rights to the Supreme Court and trying to make them look like they are matters of interpretation, but at the end of the day, they are seeking to enforce her fundamental human rights, is for me a bit surprising and alarming. And that's why I think that any time she wants to do this in public, go the emotional tangent, as my colleague said, she ends up revealing the very thing that will be met for you to be removed, which is incompetence. How can the Chief Justice go to the Supreme Court and ask that they enforce your fundamental human rights personally? How?
On 3FM, the best in the morning.
That alarms every lawyer. And then we'll now begin to ask questions that, so is this the depth of interpretation of the law that the Chief Justice had that we never knew? You get the point. So we return to the procedure. Whatever happens, we will return to the proceeding, and it will end where it must end, depending on whether the stated misbehavior or incompetence is proven.
Thank you, gentlemen.
It is not proven. That's why.
Thank you. Osman Alassan is a private legal practitioner, also joined on the line by Leberech Chris Malbehesi. He's also a private legal practitioner. Gentlemen, I wish you well for the day and on your endeavors for today.
Much.
We're grateful.
Thank you so much.
Thank you so much. We're grateful. And that's our time here. It's 12 minutes after 9 on Sunrise on 3FM 92.7.